Welcome to an introduction to Crown-Indigenous treaties and treaty law in Canada with Professor Robert Hamilton. Robin Sutherland, Nishnagas, Peterbeck and Dojaba. My name is Robin Sutherland, and I am from Fort Albany First Nation. I am the Director of Indigenous Relations at the Boer-Alaskan Faculty of Law, Lakehead University, and I will be your MC for this event, where you'll be hearing a presentation from Professor Robert Hamilton, followed by a question period. We are thrilled to have you join us for Treaties Recognition Week at Lakehead University, and we look forward to the dialogue that follows, and that will hopefully continue beyond this week. Lakehead University respectfully acknowledges its campuses are located on the traditional lands of Indigenous peoples. Lakehead Thunder Bay is located on the traditional lands of the Fort William First Nation, signatory to the Robinson-Superior Treaty of 1850. Lakehead Aurelia is located on the traditional territory of the Anishinaabe. The Anishinaabe include the Ojibwe, Odawa, the Potawatomi nations, collectively known as the Three Fires Confederacy. Lakehead University acknowledges the history that many nations hold in the areas around our campuses, and is committed to a relationship with First Nations, Métis, and Inuit peoples based on the principles of mutual trust, respect, reciprocity, and collaboration in the spirit of reconciliation. Before we begin, I would like to quickly run through some housekeeping items. Participants are reminded that Lakehead University will be recording this virtual online Treaties Recognition Week presentation. We are doing this to preserve a record of the event in the university's archives and to publicize and promote Lakehead University. By attending, you are agreeing to be included in the recording and its public dissemination in any media now known or later developed anywhere in the world in perpetuity. Thank you for joining us. Miigwech. There will be time for questions after the presentation. I encourage you all to prepare your questions as you are listening. After Professor Hamilton is finished, I invite you to submit your questions through the chat function at the bottom of your screen. If you would like to ask your question orally, you can raise your hand in the participants function. Click on More at the bottom of this feature, and then click on Raise Hand. You will be called on in the order that you raise your hand. Without further ado, it is my pleasure to introduce our guest today. Robert is an assistant professor at the University of Calgary Faculty of Law. He is a PhD candidate at the University of Victoria Faculty of Law, and he holds a JD from the University of New Brunswick Faculty of Law and an LLM from Osgoode Hall Law School. His graduate work focuses on Aboriginal and treaty rights in Canada's maritime provinces. Robert has published on a range of Indigenous rights issues, including Aboriginal rights and title, Indigenous peoples and federalism, and legal historical aspects of Crown-Indigenous relations. We are excited to have the privilege of having Robert join us for today's lecture. Professor Hamilton?
Okay. Well, good morning, or I suppose good afternoon. I'm just at the tail end of the morning here in Calgary. So just to begin, I want to thank Robin for the invitation to be here. I was really thrilled to get the opportunity to come in and speak with you today, and looking forward to a good conversation. I'm joining you today from Treaty 7 territory, so the traditional territory of the Blackfoot and Stoney and Tsuut'ina nations, where I live and work now. And I'm actually from a much different treaty context, from the Peace and Friendship territory, from Wolastoqey territory. So one of the things that I want to talk about today is how important it is to understand the distinction between these different treaty contexts and how they structure Crown-Indigenous relations and how they structure the constitutional frameworks in different parts of the country. So I've got about an hour here to talk, and then we'll open things up for conversation. I've tried to structure this presentation to be a little bit more conversational and informal, hopefully. I found to date in my Zoom experiences, it's both hard to sort of deliver a more formal lecture over Zoom, and it's also a little bit more tiring, I find, for the listener. So I've got some slides that I'm going to work through. I'll get to those in a minute, and I'm going to approach it just a little bit more extemporaneously in the hope that that makes it a little bit more engaging. So I'll find my screen share function here now. Okay, so a little bit of an outline then about what I'd like to talk about today. So I'm going to go over a brief history of treaties in Canada. Some of this may be repetition for some of you. Hopefully I can add a little bit new information. And I think this is an important way to set a little bit of the context for what I'd like to talk about today. Second, I want to talk about treaty interpretation in Canadian courts. So how have Canadian courts approached their task of interpreting Crown-Indigenous treaties? What law has developed around that? Third, I want to zero in a little bit more specifically on this question of the regulation and infringement of treaty rights. So in many of the conflicts that we see now arising in different parts of the country, this question about the scope of the Crown's authority to regulate treaty rights and their sort of lingering Crown authority to infringe those treaty rights sits underneath an awful lot of that. So as a sort of case study then to look at contemporary treaty rights and some of the issues that I'd like to raise, I'm going to look at the Sibiknikatik fishery. So this is the fishery that I'm sure you've all seen in the news, and I think you may have had a presentation on earlier this week, the Mi'kmaq fishery in Nova Scotia and some of the conflicts that have come up there. I wanted to look at this in a little bit of detail to try to tease out how the principles that the court has developed have applied in this specific context and what some of the consequences are. Finally, I'm going to go to some outstanding questions. So some of the lingering questions that I have about this doctrine, how it's been applied, and how it has or has not been successful in mediating Crown-Indigenous relations. So one of the things that is important to remember is that while we most often focus on Crown-Indigenous treaties in Canada and in our legal discussions, it's important to remember that Crown-Indigenous treaties were built on a longer history of treaty making in North America. And it drew on the treaty making experiences both of Indigenous peoples and European parties in different ways. So throughout Canada, there were long histories of inter-Indigenous treaties that preceded the arrival and postdated the arrival of Europeans. So for example, the Blackfoot entered into treaties with Cree and the Kootenai, the Haida and Haisla on the West Coast entered into treaties, the Haudenosaunee and Anishinaabe had treaties, and that those were commemorated in the wampum that I have a picture of here, right? That this is how those treaties and those constitutional relationships were kept track of, were written, were recorded. And importantly, Robin mentioned confederacy, right? We know that Indigenous peoples arranged themselves politically in a number of confederacies, and very frequently those were bound together through treaty relationships. So one of the ones that we're going to that is important in terms of the specific context I'll look at today on the East Coast is the Wabanaki Confederacy. So the Wabanaki peoples, the Mi'kmaq, Wolastoqey, Passamaquoddy, and so forth, were allied in the Wabanaki Confederacy. So there are these long histories of Indigenous treaty making that inform the background for Crown-Indigenous treaties. There are also the inter-European treaties, right, that were of considerable importance in structuring the constitutional relationships here. So the Treaty of Utrecht, for example, this is a picture of the negotiations at Utrecht for the Treaty of Utrecht. Britain, the English acquired the maritime provinces, or at least peninsular Nova Scotia in 1713 by way of the Treaty of Utrecht, right? And this was the fifth time that that territory had been transferred between European powers by treaty between themselves, right? So England, Spain, France, they negotiated and exchanged territory in North America by treaty, and those treaties had considerable impacts when it came to the processes of colonization in which Crown was entering into relationships with Indigenous peoples. So the Treaty of Utrecht, as I mentioned, is one very important one. The Treaty of Paris, right, where Quebec was ceded to Britain in 1763, things like the Oregon Boundary Treaty in 1846 that determined the boundary between the British colonies and the United States and the prairies. So all of these are important examples of how inter-European treaties and forms of diplomacy shaped the legal relationships in this place as well. And these two, though they're often considered quite distinct, right, inter-Indigenous treaties and inter-European, they actually did speak to each other in some ways. So in the 1726 treaty, which is a treaty between the Wabanaki peoples and the British Crown, the British explicitly sought to have the gains that they made at the Treaty of Utrecht recognized by the indigenous peoples. So they took the diplomacy that was happening in the inter-European sphere and sought to have that recognized by their indigenous allies. They understood that the claims that they were making at European law were merely paper claims, unless they also made those through forms of diplomacy with indigenous peoples. And in fact, they were quite explicit about the need to engage on the basis of indigenous diplomacy. So if you look, for example, to the instructions that were given to the governor of Nova Scotia in 1719, Richard Phillips, those say explicitly, engage on the basis of Algonquian diplomacy, right? So he's being instructed, go engage according to the norms of diplomacy, the protocols of diplomacy of the indigenous peoples that you're engaging with. So that brings us to the Crown-Indigenous treaties. So the treaties between the Crown and Indigenous peoples themselves. So again, many centuries of history to draw on here. One of the most prominent examples, of course, is the covenant chain example of where first the Dutch and then the British were brought into the covenant chain relationships of the Haudenosaunee and the Anishinaabe. And that's an important form of treaty making. We tend to focus on the more modern 19th century treaties, but it's important to understand that they were preceded by others as well. So the picture on the screen here is actually a picture of the written version of the agreement that was come to in Montreal during the Great Peace of Montreal in 1701. So frequently it's thought that the French did not engage in treaty making. And while they were not as prolific as the British, the Great Peace of 1701 actually stands as an example of the French engaging in complex, extremely complex diplomatic forms of treaty relationship with the indigenous peoples, trying to really restructure the basis of political authority throughout New France and engaging with dozens of indigenous nations on that front. So this is the map that we get of Crown-Indigenous treaties in Canada. And this gives us an account of the different types of treaties that we see. I mentioned at the outset that it's important to understand the many different types of treaties and how they structure relationships and rights and obligations differently. So on the right, and what we will come back to later, you'll see in green the peace and friendship treaties. So these are 18th century treaties. They're signed between 1725 and 1779. And I'll say a little bit more about them later. These are treaties of peace and friendship. They do not cede land. That's been recognized by the Supreme Court repeatedly. And they structure trade and alliance. As we move westward, we see in purple treaties that I'm sure many of you are familiar with. We see the 19th century treaties, first in Southern Ontario, and then the treaties, the Robinson-Huron treaties and Robinson-Superior treaties. While at the same time as those treaties were being made, we see a series of small treaties being made on Vancouver Island. So these are not the ones that are in pink on Vancouver Island, which are modern treaties, but the small little blue spots that you'll see. So those are the Douglas treaties that were signed between 1850 and 1854, or the Vancouver Island treaties, as they're sometimes called. So 14 treaties signed on Vancouver Island, but pertaining to very small spots of land. We don't have other treaties in British Columbia, except for, you'll see the northeastern corner of Treaty 8, largely because after Governor Douglas left, the new regime that came in British Columbia said, there's no such thing as land rights anyway. Why? Aboriginal peoples don't have rights here. Why are we going to enter into treaties? The province of British Columbia maintained that position for a century, which is why Aboriginal title remained such a trenchant and important issue there. Now in blue, you see the numbered treaties. So of course, the numbered treaties being signed 1871 to 1923, and 29. And you see that these cover a significant part of the land base in Canada. The Crown position, it was and continues to be that these treaties represented a cession and surrender of the land interest. So the British position in the 19th century was there is such thing as Indian title, as an Indian right to land and Indian interest, and that has to be acquired. It has to be ceded or surrendered before settlement or development can occur. And that's what this treaty process is meant to effectuate, right? That's the process. There's a recognition of title, but the need to acquire a cession of that. Now, of course, this is hotly contested along a couple of fronts. Many Indigenous peoples say that's not what we agreed to, right? It's not in the oral records. It's not what we believed we were entering into. We did not mean to cede and surrender territory absolutely forever. And a second sort of line of argument is to say, to the extent that surrenders were made, it was only the depth of a plow. So there is an Aboriginal title case in Alberta, for example, that's in the very early stages, claiming Aboriginal title to what's underneath that, right? To the mines and minerals underneath that initial piece of sort of topsoil that's ceded. So important to understand that there are considerable differences about that. The position at Canadian law is that these are treaties of cession and surrender. In pink, we see the modern treaties, right? So you see that it's not a coincidence, right, that they sort of fill up the space that the numbered treaties don't. The recognition, again, there's Aboriginal title, there are rights to land, there are rights to resource use, and that to achieve certainty, to formalize relationships, the Crown wants to enter into treaties. So here you see the first one in 1975, which immediately followed the Calder decision in 1973, where the court said for the first time, Aboriginal title is a justiciable legal interest, right? We can recognize that as a justiciable interest. We get the introduction of the modern land claims process, the James Bay Treaties in 1975, and then we have quite a period of sort of, it's not quite inaction because negotiations are happening, but much slower progress. You get the Yukon Umbrella Agreement in 1993 and a number of agreements that develop thereafter. The development of Nunavut, which is a different form, but also under the modern land claims process, Inuvialuit, and a few agreements starting to pop up in British Columbia. So the first is the most northern one that you see, which is the Nisga'a Agreement. And then you see the Tla'amin, Seychelles, West Bank, and Malnoustet down south. So those are all the modern treaties. Okay, so all of these treaties that I just discussed are now dealt with, at least judicially, under the framework of the Constitution Act 1982 and Section 35, which says the existing Aboriginal and treaty rights of the Aboriginal peoples of Canada are hereby recognized and affirmed. Right, so this recognition and affirmation of Aboriginal and treaty rights, all treaty rights in Canada under the various types of treaties that I just discussed. I should put a little bit of an asterisk there, perhaps not the inter-Indigenous treaties. So that's a complicated and interesting legal question that I don't want to roll that into this right at this moment. But numbered treaties, peace and friendship treaties, the Douglas treaties, Robinson Superior, the modern treaties, they're all taken care of now or judicially dealt with under Section 35 and the framework that the court has developed there. So now that's a little bit of a brief, inadequate, but hopefully adequate for the purposes of our conversation, overview of some of the historical basis of the treaty relationships in Canada and the different types of treaties that exist. So what has the court said then? What are the principles of treaty interpretation? How does it manage when treaty rights issues come before the Supreme Court? What does the Supreme Court apply? What are the rules of engagement and the rules of interpretation? So there are 9 principles that were articulated in the Marshall decision. They were articulated by then Justice McLaughlin before she was Chief Justice. And they have been taken up since as sort of a comprehensive articulation of the principles of treaty interpretation in Canada. So I'll go through those quickly here. So first, Aboriginal treaties constitute a unique type of agreement and attract special principles. Okay, so that's the first important point is we're not going to interpret these in the same way that we might interpret an international treaty or a contract, for example, right? They have their own principles of treaty interpretation. They're due special type of treatment. Treaties should be liberally construed and ambiguities or doubtful expressions resolved in favor of the Aboriginal signatories. So this is a long-standing common law position. As I'll discuss later, the court essentially adopted this from the US case law, a case called Jones and Meehan, which said the concern essentially was one with power imbalance and differences in language, right? The treaty is being written in the language of one party. We know that there were power imbalances in negotiations. So where we find ambiguities, doubtful expressions, and so forth, we're going to try to interpret those liberally and resolve those ambiguities in favor of the Aboriginal signatories. The goal of treaty interpretation is to choose from among the various possible interpretations of common intention, the one which best reconciles the interest of both parties at the time the treaty was signed. So this one we'll see becomes a major feature of the court's jurisprudence, at least in cases where it's trying to give a robust articulation of the nature of the treaty rights. I'll briefly discuss the Grassy Narrows decision, where the court seems to have forgotten that all of these principles exist. So it's the Supreme Court, so it can do that if it likes sometimes. Okay, so the third one then is the goal of treaty interpretation is to choose from among the various possible interpretations of common intention, the one that best reconciles the interest of both parties when the treaty was signed. So here the court says what we're going to do is look back, try to ascertain what the common intention of the parties was. So look at historical context, look at the materials that are available to us in terms of historical materials, accounts of the treaty negotiations and so forth, try to ascertain what was the common intention of the parties, right? They came together in negotiation, they entered negotiation, they had discourse trying to develop a set of rules, protocols, guidelines that would shape their relationships. Well, what was that intention? What were they trying to do? Ascertain that common intention and try to give voice or try to apply the one that best reconciles the interests of the parties when the treaty was signed. Fourth, in searching for the common intention, the integrity of the crown is presumed, the integrity and honor. Okay, so the court is not going to sort of retrospectively assume that the crown's intention may have been to undermine the Indigenous interest or to cheat them, right? You're going to presume when trying to ascertain the intention of the parties that the crown was acting honorably. So fifth, attention to the unique cultural and linguistic differences between the parties. So again, the concern here is trying to understand, and this goes back again to some of what I talked about in terms of the different backgrounds that the parties would have had, right? They had long treaty histories, they had different understandings of treaties, of political relationships, of relationships to land and so forth. So trying to understand the cultural differences and the linguistic differences when ascertaining those common intentions. Words must be given the sense that they would naturally have held for the parties at the time, right? So the idea here is to make sure that you're trying to understand words as they would have been used. Seventh, get away from contractual or technical interpretations of treaty wording. So again, this gets back to the previous points that have been made, right? Understanding that written document was framed by one of the parties, was framed in the legal language of one of the parties, is not necessarily representative of the nature of the agreement or the common intention of the parties. So you're going to want to avoid a highly technical or contractual interpretation of treaty wording. But the court wants to caution, while you construe that language generously, you can't exceed what's possible on the language, right? So in other words, the treaty document sort of sets a point of resistance, right? So the court can work with that language. It can try to interpret it generously. It can try to interpret it in light of the intentions of the parties and their unique cultural and linguistic context, but that wording still sets a certain sort of resistance point on the interpretation, right? It has to be possible. The interpretation that the court ultimately puts forward has to be possible on the language of the treaty. Ninth, the treaty rights must not be interpreted in a static or rigid way. So they're not frozen at the day of signature, and the court has to update treaty rights to provide for their modern exercise. How effectively the court does this is a matter of some debate. I think you have to go through case by case and think closely about what it means not to freeze rights at the date and see if the court's approach actually lives up to this. So the most common example that you could use would be to say, you can hunt with a rifle, right? So we recognize a treaty right to hunt. There's no need to hunt with a musket or a bow and arrow or something to that effect, right? You welcome to hunt with a modern rifle. So that's the sort of modern exercise. But when you start asking about maybe the types of political rights that were reserved under the treaties and that sort of thing, or in particular, as we'll see when we get to Marshall in a little bit more detail, the ability to decide who fishes, when they fish, for example, are the courts being as liberal as they sort of suggest here when they sort of adopt for the modern exercise of the right. Okay, so those are the principles of treaty interpretation as the court has laid out. Again, those were delivered by Justice Marshall in dissent, but dissenting on another point, and those have become the sort of copy and paste test, right? Most treaty cases, you'll see those 9 principles pop up. Those are that's the go-to now. So are treaty rights absolute then? So a follow-up question. We have all these principles of interpretation, right? Parties come to the court, they have a dispute about the nature of a treaty right or the Crown's action in relation to a treaty right. And the court deploys those principles of interpretation in trying to assess, yes, there is a treaty right, what is the scope of it? Once they've determined that, is that treaty right absolute? And there are 2 ways to think about this. And as I'll highlight when we get through, I think confusion or some of the gray area that the court has created around this issue has given rise to some of the problems and disputes that we see now. So the first way to think about this is in the context of infringement. So can a treaty right be infringed? The second is the context of regulation. So once a treaty right is recognized, can it be regulated? And if so, to what extent? So the answer to both those questions, according to the Supreme Court, is yes. Okay, so the court said in Badger, the impugned provisions, that is of legislation impacting a treaty right, should be considered in accordance with the principles set out in Sparrow to determine whether they constitute a prima facie infringement of the treaty rights as modified, and if so, whether the infringement can be justified. So in Badger in 1996, then, the court applies Sparrow, case from 1990. And in the Sparrow case, the court said Section 35 rights are not absolute. Okay, Section 35 rights can be infringed so long as, and we'll talk about the test in a minute, essentially it's a modified Oakes type analysis. So what about regulations? Can the rights be regulated? And again, this goes back to some of the foundational problems that have been animating Section 35 case law from the beginning. Indigenous peoples from Sparrow onwards have consistently argued the right, say to hunt, includes the right to regulate the right, the exercise of the right. So if we have a recognized right to hunt, that includes a recognized right to regulate our own exercise of the hunting right. The courts have consistently sort of pushed back against that. And so we see, for example, in Marshall, the court explicitly says such regulations would not constitute an infringement that would have to be justified under the Badger standard. Okay, so regulations in and of themselves do not necessarily constitute an infringement of a treaty right such that it requires justification. So I'm going to unpack that just a little bit and see what that means. So what does it look like to assess an infringement of a Section 35 right? So this is the test that emerges from the Sparrow decision. So again, Sparrow is the first case to deal with Section 35 rights, 1990, right? So it's by the time that a fact pattern sort of rolled out and made its way up to the Supreme Court after 1982, Sparrow is the first case. Sparrow doesn't really deal though so much with the question of how do you define an Aboriginal right under Section 35? Right? We don't really get the court turning its mind to that until the Vanderpeet decision in 1996. In Sparrow, the court more or less accepts. It says, well, look, we know that the Musqueam have been fishing salmon in this area since time immemorial, that it's an integral part of their culture. Okay, there's an Aboriginal right to fish the salmon. The question they turn their mind to is, what does it mean to recognize and affirm? Does that include the ability to infringe a right. And as I said, I suppose in foreshadowing a little bit, the court ultimately says Section 35 rights are not absolute, right? It sort of draws an analogy here between charter rights and Section 35 rights in saying that they're not absolute, that they are subject to infringement. It's very important to sort of bracket there and say, make the point clear that Section 35 is not part of the Charter of Rights and Freedoms, right? The court will sometimes, I mean, people who are not the court very, very often refer to it as part of the charter. The court sometimes will refer to it as part of the charter. It's not, right? It sits outside the Charter of Rights and Freedoms, and so it's not actually subject to Section 1. Section 1 is the limitations clause that says effectively that the rights are not absolute and can be subject to infringement for some purposes or limitation for some purposes. So the court has to get this from somewhere else. I'll talk in a minute about some of the ways that it's been thought about where the court gets this authority. But what is the test that they lay out? So again, this is sort of like a modified Oakes type analysis. They say, first, if the right's not been extinguished, so prove that it has not been extinguished, can the claimant show a prima facie infringement? And it's worth remembering these criteria for when we get back to our discussion of Marshall in a couple of minutes. So first, demonstrate a prima facie infringement. Is the limitation unreasonable? Does it pose undue hardship? Does it deny the rights holders the preferred means of exercising their rights? Really want to underline, I don't have underlining capacity right now, but I'll underline that one for later consideration. Second step, if prima facie infringement is shown, can it be justified? So here you're shifting the onus to the Crown. The Crown has to show that this infringement can be justified, this prima facie infringement. Is it a valid legislative objective? Okay. Again, in the news, frequently you will have heard the word conservation come up frequently, right? Conservation, conservation, conservation. The argument about conservation when we talk about treaty fishing or treaty rights to fish lobster, for example, in Nova Scotia, is the Department of Fisheries and Oceans looking at sparrow and badger subsequently has said conservation is a valid legislative objective. It's a valid purpose for enacting regulations that might limit the scope and exercise of the treaty right. So in sparrow, conservation is identified as one of those valid legislative objectives, and that's why it's been consistently part of the discourse in that way. If the Crown has a valid legislative objective, is the government acting in a way that's consistent with its fiduciary duty? So minimal impairment, right? Did it impact the right as little as possible? Were the claims given priority over other groups? Again, put a underline on that one. Was the affected group consulted? And that ends up eventually turning into the duty to consult and accommodate. If there was expropriation, was there fair compensation? So some of the criteria that the court's going to look at. So we have onus on the First Nation, demonstrate that there's an infringement. If they can demonstrate a prima facie infringement, onus shifts to the Crown to demonstrate they had a valid legislative objective and that they were acting in accordance with the fiduciary duty. And these are some of the things the court will look to in assessing that. Now, where does the authority for this come from? So the court is relatively clear about this in Sparrow. The court says, well, there was from the outset never any doubt that sovereignty and legislative power, and indeed the underlying title to such lands vested in the Crown. So essentially what the court argues in Sparrow is, again, there was never any doubt that the Crown possessed the authority to regulate and infringe Aboriginal rights. They were never presumed to be absolute at common law because the ultimate authority of the Crown was never in question. So on this view then, what Section 35 does is it gives the court a basis to supervise the discretionary authority of the Crown. So the rights that are in existence, that are recognized and affirmed in Section 35, come in a non-absolute form, right? They're always already subject to the unilateral Crown action. And Section 35 then provides a basis for the courts to supervise that and ensure that the Crown is acting in accordance with its fiduciary duty. So that's the that's the position. Now, how convincing you find it to say there was never any doubt, I mean, there's an awful lot of literature looking at this, right? Who never doubted that, right? And what's the outset? Since when? So there's a lot of very strong critique of this position, but it's important to understand the legal basis for what's going on here, right? And how the court justifies the position that Section 35 rights are not absolute and can be infringed. Because again, they're not subject to Section 1, right? And the court's explicit on that point in Sparrow. Okay, so what about regulation then? And the reason that regulation comes up here is, again, remember the points that were talked about in Sparrow. Does it deny the rights holder their ability to exercise the right as they would like to, for example, right? All they have to do is demonstrate a prima facie infringement. So the question is, well, doesn't any regulation then constitute a prima facie infringement? I mean, any regulation, say the imposition of a fishing season, certainly seems to undermine the Indigenous treaty rights holders' ability to exercise the right in their preferred means. So isn't any regulation actually kind of a prima facie infringement? And the court says no, okay? No, so long as the regulations effectively allow for the exercise of the right. That's the way that the court wants to frame this, right? So they talk about this in Marshall, and this is the first quote. I do apologize for all of the text here. I wanted to grab these different quotes so that the pinpoints are available. The court talks about this in Marshall, and we'll come back to it. They say such regulations would not constitute an infringement that would have to be justified under the Badger standard. And I want to pause there as well. Something that people may want to consider is in Badger, we get the application of the Sparrow infringement principles to treaty rights. Okay, and the court says, look, treaty rights and Aboriginal rights are different, but they're similar enough that we're going to apply the Sparrow framework. I'll just leave that. Something to think about and consider, right? Think about the court's reasoning there and whether the types of negotiated agreements that we see under treaties that structure negotiated bodies of intersocietal law are actually equivalent in the same way that the court thinks to Aboriginal rights, which are recognized on the basis of prior occupation and customary and traditionary practices, right? Worth thinking about whether that's a justified leap for the court to take. Nonetheless, so regulations don't constitute an infringement that would have to be justified under Badger. Okay, so now we've opened up a gray area that has caused an awful lot of problems going forward. Well, if regulations don't necessarily constitute an infringement that has to be justified, what scope of regulations are permissible? To what extent can the right be regulated? This is what the debate on the East Coast is essentially boils down to, right? What is the permissible scope? So the position of the Department of Fisheries and Oceans is, well, look, we've entered into agreements that allow you access to the commercial fishery. So yes, that's all happening under the auspices of DFO regulations, but look, that's not necessarily an infringement of the right. So long as you can still exercise the right, the regulations do not constitute a prima facie infringement that has to be justified. So that's really one of the turning points here. Now, I wanted to mention as well, they're not as relevant in the Marshall decision that we'll talk about a little bit more in a minute, but the extent to which taking up of land under numbered treaties is considered an infringement sort of parallels the discussion of regulation in an important way. So the court in Grassy Narrows, for example, says not every taking up of land will constitute an infringement of the harvesting rights set out in Treaty 3. So the argument again is, look, if the Crown is taking up land under one of the numbered treaties and those have an impact on the harvesting rights or the resource rights that are recognized under the treaty, that's a prima facie infringement that's going to require justification. The court rejects that, right? The court says, no, not every taking up of land will constitute an infringement. And they repeated that, or they said it first, I guess, in Miksut Cree in 2005, when they said not every taking up by the Crown constituted an infringement of Treaty 8 that must be justified according to the test set out in Sparrow. So the court's basis for doing this is to say, well, the treaty contemplated taking up of land. The treaty, it's explicit that the rights are recognized subject to the taking up of land for various purposes. So in the court's view, not every taking up of land therefore constitutes an infringement, because that's sort of, you could see it as a treaty right of the crown, right, to take up the lands in this way. So even though it might have an impact on rights, on Indigenous rights that are recognized under the treaty, it's not necessarily an infringement. Now in Grassy Narrows, the court goes a little further here and actually says, if the taking up leaves the Ojibwe with no meaningful right to hunt, then that might give rise to an infringement case. So here you see the box of permissible regulation really growing quite large, and the one that constitutes prima facie infringement almost evaporating, right? No meaningful ability to exercise the right. That sounds a lot like an extinguishment to me, not an infringement, right? Remember, infringements can still be justified. So the court has really pushed quite a ways over, I think, in that. But it's worth looking closely at the court's reasoning here and trying to tease out how it's walking this line. Okay, so let's go to our example or case study then. Got about 15 minutes left, so we'll dive into this in a little bit of detail. So the Sepiknagatik moderate livelihood fishery. So this is, you will be familiar with this from the news, I'm sure, right? This is beginning in September, the Sepiknagatik First Nation, a Mi'kmaq First Nation in Nova Scotia, established their own moderate livelihood fishery, right? So it was recognized in the Marshall decision that the Mi'kmaq have a right to fish and to trade the goods they've harvested in order to obtain a moderate livelihood. Most, I think, Mi'kmaq nations on the East Coast have not been content with the Department of Fisheries and Oceans position on this, which has been to say, well, we'll give you access to the commercial fishery, right? So we'll arrange for licenses and fishing boats and fishing gear for you to participate in the commercial fishery. And most Mi'kmaq First Nations have said, well, no, we want to establish our own moderate livelihood fishery outside of the established commercial fishery. So this is what the Sepiknagatik First Nation has done. They established their own licensing regimes, they licensed their own fishers, and they allowed them to go out and fish. And again, recall what I said, one of the big debates in Section 35 has been this question of regulation and whether the right includes the right to regulate the exercise of the right. Okay, and of course we know that the results of this have not been good, right? So a lot of violence has ensued. Non-Indigenous fishermen really took it upon themselves to try to regulate the exercise of this right. So they began by taking traps out of the water. They took a number of Indigenous traps out of the water and left them at the DFO office, trying to demand that the DFO exercise or bring enforcement against the fishery. When that didn't have the desired effect, they turned to violence, right? So there was an incident where they trapped a Mi'kmaq fisherman in a lobster pound, destroyed quite a substantial amount of lobster. You can see here something from Twitter as this was unfolding, someone describing this, right? Cut the power, ransacked buildings, poured chemicals on lobsters, lit a van on fire, stole lobster traps, and all of that has been subsequently confirmed in media accounts as well. So a lot of violence that emerges in this context. Now, what's the treaty context then of this dispute? So the treaty context is, we're in the Peace and Friendship Treaty context. I mentioned earlier, these are signed between 1725-26 and 1779. And it's a whole host of treaties that really renew that initial agreement that's made in 1725-26. So we have subsequent treaties being made in 1749, 1752, 1760-61, and then 1779. And the 60-61 treaties are the ones that are at issue here. Now, these treaties have to be read together. You have to read all of them together, in my view, to fully understand what the rights and obligations of the parties are. And when you do that, you see some fairly consistent articulations of the types of rights and obligations that the parties hold. The treaties recognize shared and exclusive jurisdiction in a number of issues. So some issues where the Crown and the Indigenous peoples both have forms of jurisdiction in relation to given issues, others where they recognize exclusive. So in criminal law matters, for example, right, the British will deal with the British, the Mi'kmaq will deal with the Mi'kmaq, right? So they clearly define areas of exclusive jurisdiction in that way. The treaties deal with future settlement. Remember, I said they don't cede land. What they say is that the British Crown is going to get permission before it goes forward with other forms of settlement. So the Mi'kmaq agree, the Wabanaki more generally, the Wolastoqey and Passamaquoddy and the Abenaki in New England, who actually negotiated this treaty in Boston. They agree, okay, your existing settlements will be fine with those. Future ones will require negotiation. Okay, so actually, I've developed the argument elsewhere that this is actually a powerful recognition of Indigenous land rights, but we'll bracket that for now. They also recognize hunting and fishing rights, so rights to resources, and that's what we're going to get into a little bit here. So within Peace and Friendship Treaty territory, just a little bit more specifically, when we talk about the Sipeknegatig fishery, we're talking about Mi'kmaq territory. So this is a map of Mi'kma'ki. So the 7 districts, the 7 Mi'kmaq districts, Onamag on the right, in also known as Cape Breton. This is where the Grand Council sits. And you see near Halifax here, this district is called Sipeknegatig. So, and that's where the Sipeknegatig First Nation is. If you look just over where it says Bay of Fundy, that's where the fishing disputes have been. Okay, now just quickly a little bit of contemporary context that's important to remember when we get into talking about the current dispute in particular. So following the Marshall decision in 1999, many of you may remember what was called at the time the Burnt Church lobster fishing dispute. Right? So this is at the Espanobatij First Nation in northeastern New Brunswick. And really it rolled out in very much a very similar way to the conflict that we're seeing right now. The Marshall decision was released. The Mi'kmaq at the Espanobatij said, okay, we're going to establish a fishery, right? We're going to regulate and license the exercise of a moderate livelihood fishery. In that case, the Department of Fisheries and Oceans itself really went into enforcement mode, right? And so there was what the picture here you see of the boat, of the DFO boat swamping the small fishing skiff. This was a conflict on the water that drew national attention and was, you know, a very significant conflict. We also have El Sabuktuk, so this is fracking disputes, Alton gas disputes, what I've called the conquered peoples disputes, and Sipeknegatig. So just a couple of quick words about each. You'll remember the El Sabuktuk fracking dispute, I'm sure. This is when the Mi'kmaq and El Sabuktuk tried to prevent fracking exploration on their territory, and it resulted in, again, considerable conflict, this time with the RCMP. Alton gas, the situation near Sipeknegatig, actually. It's in the courts, it's been framed mostly as a duty to consult issue, and it's a question of some mining debris and pollution that's entering a river. Sorry, I'm going a little bit more quickly than these. That's a more detail, of course. The conquered peoples issue. So this actually relates to Alton gas. A Crown lawyer argued in the courts in Nova Scotia that the Crown had no duty to consult the Mi'kmaq because the Mi'kmaq were a conquered people. Okay, they've been conquered, so there's no duty to consult. So that was a problem, right? That created some political issues. Ultimately, the province had to apologize for that. The lawyer was fired, and he's continuing to challenge his dismissal. This brings us to Sipeknegatig, and the reason that I give that very brief overview is just to say that it's very important to remember that trust is not necessarily at a really high level on the East Coast, right? There's quite a long history now over the last 20 years and before of disputes over land and resource uses, very fraught tensions, not only between Indigenous peoples and non-Indigenous peoples, as the highlight is in where the Sibiknagatik fishery is concerned, but between Indigenous peoples and the Crown. So not a lot of trust with the RCMP and the DFO and so forth. So it's a very fraught and volatile situation, and has been for quite a while. So that brings us again to the current day and to Sibiknagatik, and the one that really caught everybody's attention in the news, which was the burning of a lobster pound there. Okay, so what's the legal context then behind that? I've mentioned the Marshall decision a few times, right? So I'll dive into the Marshall decision a little bit as an example of the application of some of these principles. So this is a picture of Donald Marshall Jr. With, I believe, Adrienne Clarkson. I didn't double check that. Former Governor General Adrienne Clarkson. So Donald Marshall Jr. was arrested and prosecuted for fishing eels in Antigonish, Nova Scotia. He had fished 463 pounds of eels, which he sold for $787.10. And he's charged and prosecuted for having done so. He brings a treaty rights defense, right? He says, no, actually, I have a treaty right to fish and to trade in the products of that fishery. So what law does the court lay out? I already discussed the 9 principles that Justice McLaughlin, then Justice McLaughlin identified, and those have really been the ones that have guided subsequent jurisprudence, although these points from the majority are also very important. So what's the starting point in interpreting a treaty? Examine the specific words used. Okay, so this is the starting point. So yes, we're going to be interpreting written words liberally. We're not going to be too bound to them, but we are going to be, that's our starting point. Now, what about extrinsic evidence? So there was a real argument prior to this case about what types of extrinsic evidence could be brought in interpreting a treaty. So we've talked about the importance of context, cultural context, linguistic, historical context, all these things, right? Well, what types of evidence can be brought? And in particular, can extrinsic evidence be brought to bear only where there's ambiguity that needs to be resolved, or even in the absence of ambiguity? So an important question that was unresolved prior to this case. The court makes 3 points, the majority makes 3 important points in saying that extrinsic evidence ought to be available. First, the court says, look, even in modern commercial context, extrinsic evidence is available, right? Even where you have modern contracts between highly sophisticated commercial parties, extrinsic evidence can be brought to show that a written document doesn't include all the terms, right? Second, even if the treaty document purports to have all the terms, they said recent cases have said that ambiguity is not required to be able to bring extrinsic evidence of historical and cultural context. So we don't need ambiguity on the face of the treaty in order to justify bringing in extrinsic evidence in that way. Third, where a treaty was concluded verbally and afterwards written up, it would be unconscionable for the Crown to ignore the oral terms while relying on the written terms. So where the Crown writes up that treaty that was agreed to orally, and there's evidence that the oral terms, which are frequently tracked in notes that were taken by individuals who are observing the negotiations, where that written document that the Crown wrote later isn't in line with the oral terms, the court says it would be unconscionable for us to ignore the oral terms. The treaty, in other words, is the oral agreement, right? The written version helps to understand what that oral agreement was, but the oral agreement itself is actually paramount. And the bottom line, the court says, and again, this was point, I think one of the points that McLaughlin made, I can't remember which one off the top of my head. The bottom line is the court's obligation to choose from among the various possible interpretations the common intention at the time the treaty was made, the one that best reconciles the Mi'kmaq interests and those of the Crown. Okay, so this is the clause then. So taking those principles, what's the clause that was at issue? So in this case, this is what's known as the truckhouse clause. So it's agreed then, and I do further engage that we will not traffic, barter, or exchange any commodities in any manner, but with such persons or the managers of such truck houses as shall be appointed, and so on in Nova Scotia. So the idea here is that the Mi'kmaq agree, look, we're only going to trade with the British at established truck houses. Okay, this is sort of the nature. And so the question that the court has to sort of wrestle with is, well, what does this mean? What was the common intention of the parties in entering into this agreement? And I tried to find a picture of a truck house, and this is the oldest picture that came up. I don't think this is what they had in mind. This doesn't look like 1760 to me, but it's the closest that I got, so that's what we'll go with for now. Okay, so the court says, my view is that the surviving substance of the treaty is not the literal promise of a truck house, but the treaty right to continue to obtain necessaries through hunting and fishing by trading the products. So again, looking what was the common intention of the parties at the time the treaty was signed, the court looks to the oral negotiations and discussion that the Mi'kmaq wanted to obtain necessaries at the truck house. Okay, they wanted by the 1760s they had well over over 2 centuries at this point of European contact. For the Mi'kmaq, they were European goods were a very important part of their existence. So they want to obtain necessaries through trade, and specifically through trading their hunting and fishing goods, right? So trading, there's evidence of trading eels, trading other types of fish, trading pelts, and so forth. So what the court says then again is that the actual promise isn't to have a truck house there, but the right to obtain those necessaries by trading the products of traditional activities. So then the question is, well, what does that mean in the contemporary context? So here the court develops the moderate livelihood test. Now this is something that has drawn quite a bit of criticism. I don't personally I think there's a problem with it in terms of where the court's reasoning in establishing this as a limit on a treaty right, but I don't think it poses necessarily complex interpretive problems. So this is one of the ambiguities that people cite when thinking about problems on the East Coast. What the court says is, well, the ability to access necessaries translates to a right to trade for a moderate livelihood. And the court defines a little bit what it means by that. So it says, well, the concept of necessaries is today equivalent to a moderate livelihood. They say bare subsistence has receded over the last couple of centuries as an appropriate standard of life. A moderate livelihood includes such basics as food, clothing, and housing, supplemented by a few amenities, but not the accumulation of wealth. So if you want to know what's the scope of a moderate livelihood fishery, according to the court, this is what it has in mind. Right? The ability to access food, clothing, and housing, supplemented by amenities, but not the accumulation of wealth. As we'll talk about in just a minute, assuming that either the British or the Mi'kmaq intended that by entering into this agreement, that the Mi'kmaq would be rescinding their right to trade these goods for the accumulation of wealth, I think goes well beyond the interpretive principles that the court has laid out here. But I don't think that there's an actual complicated interpretive problem with figuring out what the court means by moderate livelihood. The government has been resistant to put a definition down on paper, but it's not beyond the type of interpretation I don't think that we're used to. This one, however, is the one that's caused the problem. And I discussed this in a little bit more detail earlier, right? So the question is, to what extent can this moderate livelihood fishery be regulated? So the court says at paragraph 58, the treaty right is a regulated right and can be contained by regulation within its proper limits. Okay, so what that means is so long as those regulations permit commercial fishing to the extent required to obtain a moderate livelihood, then those regulations don't give rise to a prima facie infringement. Okay, so none of the badger sparrow analysis all those steps that we looked through, justifying an infringement, valid legislative objective, minimal impairment and stuff, none of that's required. You don't have to go through that. The regulation's permitted so long as the regulations permit the exercise of the right. And so the court articulates this a little bit, but quite clearly in paragraph 61, which I won't read out, but that's what they discuss there. So this is really the point of divergence between the parties here, is what level of regulation is going to be permitted, what's conceived under the treaty in terms of regulation, and whether, for example, First Nations regulating their own fishery is part of what's recognized under this treaty right, or whether the Department of Fisheries and Oceans is correct that so long as it provides access to some form of fishing sufficient to obtain a moderate livelihood, that's given the right sort of enough room to breathe and that no infringement issues come up. Again, remember earlier I said I wanted to underline preferred means of exercising the right. That this, I think, really squarely raises that as an issue, right? I think it's difficult to say that this is not a prima facie infringement just on that basis alone, but open to dispute. Okay, so I know I'm about at an hour now. I'm going to take about 5 minutes and just pose some final questions, and then we can open it up for discussion. So for me, there's two important lessons to take from Marshall. One, you can look at some of the really generative aspects of the doctrine, right? So some of the lower court interpretations of those treaties, for example, the interpretations that the dissent would have applied to the treaty were much more constrained. So Marshall was in some sense one of the more liberal interpretations of the doctrine that were available to the court. And they were a significant advance over some of the historical articulations that were there. So, and I'll look at one really quick example of how that has played out in practice. But it continues to be constrained in really important ways, and treaty implementation has really lagged, right? So there continue to be disputes all over the country about the implementation of treaty rights, the obligations that they place on the Crown to ensure that the agreements that they've made, that the obligations that the Crown has undertaken under the treaty are actually lived up to. So I frame this latter part, especially in light of Marshall, as the unfinished business of overturning the Syllaboy decision, and I'll mention briefly what I mean by that. So what are the generative aspects? So again, the interpretive approach, looking beyond the written text, right? Even where there's no ambiguity, looking to ascertain the intention of the parties on the basis of the historical context, cultural, linguistic context, liberally construing in favor of the parties, right? In favor of the Indigenous parties, sorry. Rejecting a strict frozen rights approach, so allowing for that development over time. Don't need to fish lobster from in a traditional way. You can use a modern boat, for example, and a real emphasis on the honor of the Crown. Some of these generative aspects, the result of those, can be seen in the Ristoul decision. So this is a decision that I'm sure many of you are familiar with, and that's very important for where you are. Here, the court really tries to fill out in more detail, well, what does it mean to ascertain the intention, the common intention of the parties? And the court does a lot of work in looking at Anishinaabe law as evidence of what their perspective would have been. Right, so at paragraph 411, the court says the Anishinaabe perspective, particularly looking at the concepts of respect, responsibility, reciprocity, and renewal, as manifested in Anishinaabe stories, governance structures, and political relationships, including alliance relationships. So filling out this part, what is the Aboriginal perspective? What is their understanding of the agreements that they've come to and the nature of the rights and obligations? We have to look to Anishinaabe law as part of that context. Remember, Marshall said linguistic cultural context, for example. Here we get that filled out with Indigenous law itself. So it shows one of the sort of generative possibilities there. And I want to raise these as well. So this is the court sort of identifying this a little bit further and giving a little bit more detail around that in paragraphs 412 and 414. Now, what about the constraints? This I call the unfinished business of overturning Syllaboy. So Syllaboy is a decision from 1928. On your right, you see Grand Chief Gabriel Syllaboy. He was arrested for hunting out of season. He alleged, or as a defense, he suggested that the Treaty of 1752 permitted him to hunt. And the county court in Nova Scotia said, this isn't a treaty, okay? The Mi'kmaq have no authority to enter into a treaty. So what we're dealing with here is not a treaty. The court said treaties are acts of unconstrained independent powers, but the Indians were never regarded as an independent power. A civilized nation first discovering a country of uncivilized people held such country as its own until such time as by treaty it was transferred to some other civilized nation. The Mi'kmaq rights of sovereignty, even of ownership, were never recognized. That I think back there to that Sparrow quote. There's never any doubt. Nova Scotia had passed to Great Britain not by gift or purchase from, or even by conquest of the Indians, but by treaty with France, which had acquired it by priority of discovery and ancient possessions, and the Indians passed with it. So what they say here is no political capacity to enter into treaties. That gets overturned in the Simon decision in 1985 in a very important way. So the Simon says two really important things. First, look, the language, the biases, right, which came out in this quote that I just read, referencing civilization and so forth, these biases are no longer appropriate. Essentially, they say this is a very racist decision that's inappropriate to follow. But more importantly, they say the Mi'kmaq people would have possessed full capacity to enter into a binding treaty on behalf of the Mi'kmaq. Okay, so it recognizes their political capacity to enter into these agreements. Now, I want to compare this to what happens in Marshall in this question of the regulation of the exercise of the right. So this is a quote from Chief Justice John Marshall of the United States Supreme Court from Worcester v. Georgia in 1832 decision. There he says, we cannot adopt an interpretation of a treaty that would convert a treaty of peace covertly into an act annihilating the political existence of one of the parties. Had such a result been intended, it would have been openly avowed. So you can't take a peace treaty and give it an interpretation that annihilates the political character, right? The political nature of one of the parties. So I want to think about Marshall a little bit in that context, this issue of who can regulate the right, who has the power, whether they can be infringed and so forth. We see a major and important development in the Simon decision when the court recognizes the political capacity, right? It almost understands this quote a little bit, although the court didn't cite this case, that you have to recognize the political nature of the parties. My argument is that the rest of the doctrine that the court has developed has failed to really take this into account, right? That Section 35 doctrine has actually constrained Indigenous autonomy to such an extent that it doesn't actually recognize the political existence of the parties in a substantial way. So when we think about Marshall and what happened in that case, I think it's worth thinking through this type of frame and the extent to which this sort of unfinished business of recognizing the political capacity of the parties might still be lurking a little bit behind some of the problems that we see. Okay, one very final thing. So this, I think, also relates to what I call a missed alternative. So we talked about the need to interpret treaties in a liberal way that favors the Indigenous parties. This comes from a case called Jones and Meehan. This was sort of copy and pasted throughout a whole host of Canadian decisions. So here's a list of just some of the Canadian decisions that took up Jones and Meehan and its principles and identified them. One case that came out at the same time as Jones and Meehan that the Canadian courts have never mentioned is a case called the Winans decision, which developed what's called the reserved rights doctrine. So here the court said a treaty between the United States and the Indians is not a grant of rights to the Indians, but a grant of rights from them. In other words, anything that the Indians don't negotiate away, they keep with them, right? So thinking about the political nature, the governance powers, for example, the rights of internal self-government, the rights of self-determination that the Mi'kmaq would have held as an independent party in the 18th century in the maritime provinces, what happens if we think through Marshall in terms of this reserve rights doctrine, right? A little bit more capacious type of interpretive frame. And if we think of it in terms of the political nature or political character of the parties. Okay, so I'm a little bit over, but hopefully lots of time for questions still. So I will wrap it up there and move on. Thanks so much.
Gishimiigwesh, Robert, thank you very much. That was a very eye-opening and informative presentation. You provided us with a lot to think about. I did receive a question through email, but while I read that, I invite you all to submit your questions or comments through the chat function at the bottom of your screen. If you would like to ask your question orally, you can raise your hand in the participants function. Just click on more at the bottom of this feature and then click on raise hand. You will be called on in the order that you raise your hand. So let me just pull up my email here. Okay, this question comes from Rod Wigwas. He says, I'm from Gull Bay First Nation, Robinson Superior Treaty 1850. I'm the hereditary chief of the Loon clan, and our people fought in the 1812 war alongside with General Brent from Britain, where we were given a medallion, flag, map. Also, our people had a governing system in place. 3 questions here. Who has the right to negotiation land claims with Canada, the hereditary chiefs or Indian Act chief? 2, does Canada have the duty to acknowledge hereditary chiefs in Ontario? And 3, what can we do to get Canada to acknowledge me as a bloodline chief of the Loon clan and reclaim my lands where my people live before we were assimilated and coerced into the Indian Act?
Okay, thank you. These are really great and important questions, just small questions, right? So the first question then, so who has the right to negotiate land claims with the federal government, whether that's hereditary or Indian Act chiefs? I think that this depends to a considerable extent on the internal politics of the given nation. So the federal government does negotiate with both, right? It negotiates with Indian Act band councils. It also negotiates with hereditary chiefs. Increasingly, you've seen the federal government shift to the language of Indigenous governing body in terms of its own legislation and its own approach. And I think what the government's trying to do there is to sort of get out of the business of imposing its own idea of who ought to be the best political representative of a nation, and trying to say, well, who does the nation itself put forward as its representatives? And whatever governing body we can engage with is the one that we'll do that with. So I think historically, the government has been, resistant to engage with hereditary and traditional forms of government, but it seems to be opening up in that respect. Robin, can you remind me of the second question?
Yeah, one moment. Second question was, does Canada have the duty to acknowledge hereditary chiefs in Ontario?
Okay. So I think it's a very good question, right? I think that the government does have an obligation. I think that the honor of the Crown requires the government to engage Indigenous peoples on the terms of their own forms of governance, right? That it would be improper for the Crown to say, well, we're not going to engage with that party. And I think that you see the Crown starting to recognize this in the recent dispute in Wet'suwet'en territory, for example. The Crown has engaged with the hereditary governance there, right? So it's recognizing increasingly that this is something that it has to do. All right, should we move on to the ones in the chat?
Yes, let's start with the chat. Okay, first question from the chat. Do trap lines hold any merit since they were like private property in Treaty 3 area, for example?
Okay, very good question. So yes, I mean, trap lines are definitely important, especially when we think about the impact of the Crown taking up land. So where the Crown proposes to take up land for any of the purposes recognized under the treaty, such as mining, agriculture, forestry, and so forth, if there are trap lines in that territory, then that ought to constrain the Crown's ability to do that. So at the very least, it's going to give rise to an obligation to consult and accommodate. In some cases, that may also be grounds where you could try to say, look, court, we know that you said that infringement, that taking up of land is not necessarily infringement, but when you're taking up land where trap lines exist, which are effectively a mode of Indigenous land ownership, then that is going to give rise to an infringement, and there's going to be a higher standard there. So absolutely, the existence of trap lines in any of these considerations is going to be important.
Thanks, Robert. That question came from Virginia. This next one comes from Sam. Is there an admission of or concession of sovereignty by taking treaties to a domestic court?
This is a very good question, right? So it's always part of the challenge of sort of a strategic question of going to a domestic court and what that entails. So does going to the domestic court necessarily entail a recognition of Crown sovereignty? Because as we know, the existence of the courts are sort of dependent upon Crown sovereignty, right? The court is unlikely to say Crown doesn't have sovereignty, right? That's not a position that they're likely to take. So from an Indigenous perspective, are you acquiescing to the recognition of Crown sovereignty by engaging on that basis? I don't think so. And the reason that I don't think so is because of how many really compelling arguments are being put forward challenging the scope and application of Crown sovereignty by Indigenous nations, especially interveners in a number of these important decisions that you look at, where First Nations are going forward and saying, we don't accept the Crown assertion of sovereignty on the basis of the doctrine of discovery. Okay, full stop. We don't accept that. Now, here's how we would like this legal issue addressed, but upfront making arguments around that. And increasingly as well, I think it's possible to challenge, while not challenging sovereignty, to challenge the attributes of it, right? So not to say, well, the Crown doesn't have sovereignty, but to say, fine, you have sovereignty, but that really doesn't include very much authority over us, right? So that's a slightly different approach that in some sense, I guess it is doing what you're suggesting, acquiescing to sovereignty, but to use the property rights analogy that everyone's familiar with, the bundle of sticks, right? You're saying, yeah, you have sovereignty, but there are no sticks in that bundle, right? There's nothing left there in terms of authority. All that your sovereignty means is that you're the Crown that has the authority to enter into treaty negotiations with us.
Thanks. This next question comes from Yvonne. In the film we watched the other day, Is the Crown at War with Us? The Mi'kmaq were harassed, beaten, and forced out of the waters while exercising their right to a livelihood. 20 years later, it is happening again. Was there anything settled 20 years ago? And why is this still happening today?
Yeah, so the short answer is no, right? Nothing was settled 20 years ago. The position, the approach of the government was to enter into agreements that would allow individual First Nations ability to access the commercial fishery while maintaining the authority to say that those nations cannot license their own fisheries, right? So it's the exact same problem, the exact same legal problem that you saw in the film is the one that's playing out in Sebek-Nagatik territory right now, and will likely continue to play out. My understanding is most Mi'kmaq and Wolastoqey nations are not interested in mere participation in the commercial fishery. They want to regulate their own fishery as an exercise of their self-government and their rights under treaty. And whether, to the extent that the Crown continues to resist that and non-Indigenous individuals continue to resist that, then that conflict is likely to be ongoing, I think, unfortunately.
Thanks, Robert. Our next question is from Alyssa. As Canada moves towards implementing UNDRIP by the end of 2020, will this, or how might this affect treaty rights in your opinion?
Okay. So another great question. So partly this depends on what is meant by UNDRIP implementation, right? There are different ways that international instruments can be implemented in domestic law. One would be for the federal government to say, incorporate UNDRIP as domestic law, to say, okay, UNDRIP is now the law in Canada as if it was a statute passed by this legislature. That doesn't seem to be the path that governments are taking. Rather, they're saying our laws will be consistent with UNDRIP. So if you look at the BC Act, for example, the BC UNDRIP Act, that's what it says. British Columbia's laws will be consistent with UNDRIP. And the federal legislation that ultimately failed in the Senate said something similar, right? Federal laws will be in harmony with UNDRIP. So on that model, it's not entirely clear what immediate impact this would have on treaty rights. What this would require is that any laws that the government develop recognize Indigenous self-determination, recognize free, prior, and informed consent as the dominant principle. And so if you think about laws, for example, like the Fisheries Act and what impact it might have on the exercise of treaty rights, you can start to see where arguments can be made, right? To say, well, if the Fisheries Act and its application, the regulations under it prevent the Mi'kmaq, for example, from regulating their treaty rights, from exercising self-determination in respect of their rights, that act now, the Fisheries Act, is in violation of the Federal Implementing Act, right? You can start to see how those arguments would be made, but I'm not sure that it's going to impact the courts immediately. So this is part of why I think it's interesting to think through this in terms of the political nature of the parties and their rights of self-determination, because it requires the court to really shift their frame and how they're thinking about these relationships. So in my view, the Section 35 framework that's developed around Aboriginal rights and treaty rights is insufficient to meaningfully implement UNDRIP. It doesn't do it effectively. The question is, what's that process going to look like of the court starting to reform that doctrine so that it's in line with UNDRIP, if indeed that's the path that they do. And it's, again, a complicated question to ask, well, what might under implementation legislation compel the courts to do or not to do?
Thank you, Robert. Our next small bundle of questions comes from Max. What do you think the goal of the moderate livelihood restriction is? Is this restriction simply saying that there is no right to wealth, however, leaving the accumulation of wealth allowable? Or do you feel the mention of moderate livelihood is meant to act as a ceiling?
Yeah, so I think the fear here, and it's actually raised in the case, is that an unlimited commercial right would allow the First Nations then to license effectively a competing commercial fishery, right? So the specter that non-Indigenous fisheries associations and so forth was raising were fishing boats from all over the world being licensed by the Mi'kmaq to come into Nova Scotia waters and fish, right? So trawlers from Norway coming in and fishing in those waters licensed by the Mi'kmaq on the basis of a commercial fishery to the exclusion of non-Indigenous Canadian fishers. So I think it's very much about allocation of the resource, right? And maintaining state control over the use and allocation of the resource. I think that's the basic concern. So the idea is, well, the right to trade recognizes this commercial right, but the court was very concerned to cap that commercial right in a way that would be that it could be read in concert or alongside sort of ongoing state regulation of a substantial commercial fishery. So I think that's the purpose of it.
Congrats, Robert. A comment from Mersal. Thank you so much for this lecture. It was very informative, and thank you for everyone that put it together. A question from Sam. Can First Nations challenge Canada's assertions to underlying title to lands? If so, how or where?
Yeah,
I'm sorry, he does have a follow-up for clarification. Has Canada ever been asked to prove underlying title?
so I love these questions. So can First Nations challenge underlying title? They're starting to try to come up with ways to do it. So the problem is that the court has frequently construed underlying title as being sort of a part of the Crown's assertion of sovereignty. So the position has long been the Crown asserted sovereignty and with it asserted underlying title, right? So you might remember from property law, this is based on the doctrine of tenure, right? The idea that the Crown holds all land in under its domain, right? That it ultimately holds underlying title to everything, and any interest is derived from the Crown. But part of that, part of the court's approach to that has really ignored a long history of British imperial law of dividing between what's called imperium and dominium, right? So imperium is sovereignty, dominium is rights to property. And a lot of arguments are developing now. Kent McNeil has developed these at quite considerable length if you're looking for some academic materials on it, to say, well, look, you can divide sovereignty from title. You can divide sovereignty from property. There's no need to presume that the Crown has underlying title to these Indigenous lands merely based on the assertion of sovereignty. It can have sovereignty and jurisdiction without necessarily having underlying title. So that's one way that argument is starting to go. Another is to take something that was said in the Silcoteen Nation decision, which drives many scholars crazy because it seems to run counter to, I think, a lot of legal precedent. But nonetheless, the court says, well, what's left of the Crown underlying title? Just the fiduciary duty and the ability to encroach. So one position is to say, okay, actually, Crown underlying title is now largely symbolic, right? It means almost nothing, right? So it's almost like the sovereignty argument that I talked about later. You accept it, but then limit its attributes, right? So argue against its applicability. So both of those arguments are happening. Now, your flip argument, has anybody ever asked the Crown to prove underlying title? Those types of arguments around sovereignty of title have been tried, mostly along the lines of saying, an Indigenous person will say, well, I've been charged with, this regulatory offense, but that can't be because I'm Haudenosaunee and the Crown has no authority here, right? Which is a way to say, well, the Crown has no sovereignty or the Crown has no underlying title. Prove it, right? Those have been met with very little success to date. So I think one of there's a really compelling argument, I think, that especially where something like Aboriginal title is concerned, that the onus ought to be flipped, right? Well, prove, Crown, that you acquired jurisdiction and title over this territory. And those arguments are being made, but not very prominently before the courts yet.
Great. I think we have two more questions if you have time, Robert.
Yeah, sure.
All right, from Don. In the U.S., Indigenous nations have sovereignty, as far as I understand. Should this not have been a Section 35 right acknowledged in Canada?
Yeah, so that's right. The U.S. essentially recognizes a tripartite sovereign system, right? Federal sovereignty, state sovereignty, and Indigenous sovereignty. The question of whether that could be recognized under Section 35, the British position was always that the Indigenous nations did not have sovereignty, right? Well, I shouldn't say always. Very early on in the treaty period, there was a recognition, but thereafter it was the Crown has exclusive sovereignty. All so-called Indians have is a right of occupancy, right? They have a mere right of occupancy, not an actual right of governance itself. This goes back, I think, to the Marshall decision that I discussed. Okay, so I discussed the Worcester decision, which recognizes the political existence and political character of the parties. Canadian courts much more frequently cite the first of the Marshall trilogy, which is Johnson and McIntosh, which provides a much more constrained interpretation of the place of Indigenous peoples in the constitutional order. So the Canadian courts have sort of tracked Johnson and McIntosh in a way that has situated Indigenous peoples as always subjects of the Crown, right? Always as having been subjects to Crown sovereignty, not as co-equal sovereigns. And to the extent that Chief Justice Marshall really revised his views by the time he got to Worcester, Canadian courts really just ignored those later decisions. They haven't engaged those with much in very much of a concrete way. So there are arguments around Section 35 as recognizing an Indigenous head of power. And if it's an Indigenous head of power, then you might start to argue, well, then that means that we too have more of a tripartite structure of sovereign authority. So federal government under Section 91, provinces under Section 92 of the BNA Act 1867, and Indigenous people under Section 35. So that's a possible line of argument, but the reasons that the US have recognized it and not Canadian are, I guess, to date, been fairly entrenched.
Great, thank you, Robert. And our final question from Dana is, how can the government sell Crown land when it was not bought?
Yep, so the position of the Crown in most of the country was that it was effectively bought, right? So that's been the position under Robinson, Huron, and Superior treaties, and the number treaties was that they acquired cession of land in exchange for provision of reserves and hunting and fishing rights and the enumerated benefits under the treaties. Otherwise, it's more or less been because we say so, which is not a particularly satisfying answer, right? It's been, well, there's no Indigenous land right here, so who owns it? Well, the Crown owns it, right? It's been basically the sort of bare assertion of sovereign authority, which permits the Crown to have sovereignty and underlying title over the land. And Crown land itself is sort of a result of that process, because Crown land is created through Crown lands legislation, right? So the idea is that the Crown has legislative authority over that territory and then creates legislation that makes it into Crown land. And I suppose more basically, the argument from the provinces is Section 109 of the Constitution Act 1867 recognizes that all lands are held by the Crown in right of the province. Right, so all lands subject to any pre-existing interest. So if you can show, and this goes back to the earlier question about reversing the onus, right? If you can show that there's a pre-existing Indigenous interest, okay, then that interest takes, burdens the provincial interest. But absent that, Section 109 says that all of these lands are held by the Crown in right of the province. So I know it's not necessarily a satisfying answer, but I think that's the legal answer.
Miigwech, Robert. I would just like to remind everyone that Treaties Recognition Week at Lakehead wraps up tomorrow with a closing ceremony and a presentation titled What Treaties and Right Relations Offer Canadians with Dr. Cynthia Wesley-Eskimo at 2:30 p.m. tomorrow. Gitchen Miigwech, Misaway, big thank you to everyone for joining, for your questions. Miigwech to our guest, Professor Robert Hamilton, for sharing your voice with us today. Miigwech to Lakehead University, the Office of Indigenous Initiatives, Port Alaskan Faculty of Law, and the library for their sponsorship and support with this event and all events planned for Treaties Recognition Week. Finally, special miigwech to Sheila Pelche Demera and Anna Chief for all their hard work behind the scenes this week. Miigwech, everyone. Washe.